18 CF 13676. I can enumerate those for the court now if you would like, and then the state will be null prosing the balance of the counts. He will be pleading to all counts in 19 CF 3914. In short, Your Honor, he would be entering pleas of guilty to all of the video voyeurism counts. The non-video voyeurism counts will be null prosed.
Ms. Derry?
Yes, Judge, that's correct, Judge. Good afternoon. And I can put those numbers on the record for you. As to 2018 CF 13676, pursuant to the plea agreement that's about to happen and that has already been filed by Mr. Suarez, the state will be announcing a null pros of counts 2 through 87 and also counts 355 through 372. Mr. Ackett will be entering a guilty plea to 323 counts of video voyeurism by a school employee, defendant 18 or older. And as to that case, he will also be entering a plea of guilty to 1 count of video voyeurism on an adult. And then as Mr. Suarez said, as to the 2019 case, he will be pleading guilty as charged to all 27 counts.
Okay. Mr. Ackett, can I have you please raise your right hand? Do you solemnly swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, you may put your hand down. Will you state your name for the record, please?
Mark William Ackett.
All right, Mr. Ackett, I am reviewing the plea paperwork in your case. By the way, Ms. Derry, I don't have the, or I don't see anyway the score sheet.
Yes, ma'am. I was going to file that following the plea prior to the sentencing. However, I can email it to you right now if you'd like, if that would be better. I wasn't sure if you wanted it now or at the time of sentencing.
I have it both, I guess, if you don't mind.
Yes, ma'am. No problem. Should I email it to your judicial assistant?
You can email it to me.
Okay. I don't have that email.
It's wardle@fljud13.org. All right, Mr. Ackett, I am reviewing your plea paperwork. Did you have a chance to go through all of this with your attorney, Mr. Suarez?
Yes, Your Honor.
Did he answer all of your questions?
Yes, Your Honor.
And are you satisfied with his services?
Yes, Your Honor.
Did you have enough time to consider this decision in advance of today?
Yes, Your Honor.
And do you have any questions at all for me?
No, Your Honor.
All right, so let's talk a little bit about your cases and your charges. In case 19 CF 3914, you're charged in counts 1 through 13 with video voyeurism, defendant 24 or older, victim less than 16. Those are each second-degree felonies punishable by a maximum of 15 years Florida State Prison. In that case, you're charged with counts 14 through 27, third-degree felonies, video voyeurism, defendant 19 or older. In that case, do you understand those are your charges?
Yes, Your Honor.
In case 18 CF 13676, in counts 1, 88 through 354, and counts 373 to 427, you're charged again as with second degree felonies of video voyeurism, school employee, victim 18. I guess, is that victim 18 or older in those cases, Ms. Derry?
No, it is for the school employee.
School employee 18 or older, is that right?
Defendant 18 or
18 or older.
Yes, ma'am.
Okay, and then in that case also, you were charged with, in count 428, a third degree felony, video voyeurism, defendant 19 or older. Do you understand in that case, those are the charges?
Yes, Your Honor.
All right. In these cases, as to these charges, sir, how do you wish to plead?
Guilty, Your Honor.
By pleading guilty in these cases, you understand you're waiving many important rights, including a right to a jury trial.
Yes, Your Honor.
Do you understand that you're giving up other rights, like your right to remain silent and your right to confront any of the evidence the state would put on against you? Do you understand that?
Yes, Your Honor.
Are you knowingly and willingly waiving all of these rights?
Yes, Your Honor.
Do you understand that you're waiving your right to be physically present in front of me today for your plea and sentencing?
Yes, Your Honor.
You understand, Mr. Ackett, as I know that you've gone over with Mr. Suarez, this is structured as an open plea to the court, which means that your sentence as to these charges is completely within the court's discretion. Do you understand that?
Yes, Your Honor.
Has anyone promised you or assured you anything with respect to your sentence if you were to plead open to me?
No, Your Honor.
With respect to the rights that you're giving up in this case, has anyone forced you to make that decision?
No, Your Honor.
Are you making this decision of your own free will?
Yes, Your Honor.
Are you under the influence today of any drugs or alcohol?
No, Your Honor.
Any prescription or non-prescription medication?
No, Your Honor.
Have you been diagnosed with any mental health issues?
Yes, Your Honor.
Are you taking prescriptions for anything?
No, Your Honor.
With respect to your mental health today, have you been able to understand all of the questions that I'm asking you?
Yes, Your Honor.
Are you thinking clearly today?
Yes, Your Honor.
And again, you've had enough time to consider this decision and speak with your attorney about it, correct?
Yes, Your Honor.
Let's talk a little bit more about the open plea. I'm reviewing the score sheet that I just received from the state. What is his possible maximum exposure here, Ms. Derry? Ms. Derry, I'm sorry, you're muted.
The maximum exposure is life in prison, Your Honor.
So, Mr. Ackett, I just want to make sure, and I don't know what the state, if the state will recommend or ask for anything specific in your case other than life, but I just want you to understand that with an open plea, your exposure here right now could be a maximum of life. Do you understand that?
Yes, Your Honor.
Okay. And I just want to make sure that you don't have any questions for me either about the open plea or about anything else that we've talked about so far.
No, Your Honor.
Okay. And again, with respect to the open plea, you understand that regardless of what the state asks for and regardless of what your attorney asks for, the court can and will impose a sentence that I believe is appropriate up to and possibly including the maximum in this case, which is life. Do you understand that?
Yes, Your Honor.
Okay. Do you have any questions for me so far, Mr. Ackett?
No, Your Honor.
All right. And you told me already that you're satisfied with Mr. Suarez's services that he's provided in these cases, correct?
Yes, Your Honor.
Is there anything else you want him to work on or look into or ask me about? Obviously, we're going to be setting off sentencing here, but is there anything else before you do the plea today that you want him to work on or do for you?
No, Your Honor.
You understand if you are not a United States citizen, you may be deported as a result of this agreement.
Yes, Your Honor.
All right. Ms. Derry, may I have a factual basis when you're ready, please?
Yes, ma'am. As to 2018 CF 13676, on September the 11th of 2018, a minor student at Bloomingdale High School was changing inside of the classroom in the fashion design classroom that Mr. Ackett was responsible for and was the teacher of. During the time that she was changing, she observed a box on a shelf and appeared to see a light coming from that. She went inside that box and located a cell phone that appeared to be actively recording. She then found a second cell phone and responded to the principal's office at Bloomingdale High School to turn these cell phones over. Law enforcement was subsequently contacted. They went into that room, located those devices, and took photographs of them in the position that they were. Law enforcement made contact with Mr. Ackett that day. And post Miranda, Mr. Ackett provided a statement admitting that he had in fact been recording students without their knowledge during his time as the teacher of the fashion design class at Bloomingdale High School. Law enforcement conducted search warrants on the devices that were located, as well as on all of the electronic devices that Mr. Ackett had possession of and access to during his time at Bloomingdale High School. A result of that search warrant revealed 125 students who were depicted in those videos in states of undress, states of changing clothes, some depicting complete nudity that had been recorded on those devices that only Mr. Ackett had access to. Also depicted in those videos was Mr. Ackett himself accessing the cameras, accessing the phones, removing them, turning them in different positions, and manipulating them at various times while putting them in that location in the dressing room. Mr. Ackett again had admitted to his possession and control of those devices. The 125 students were all actively students at Bloomingdale High School at the time. Mr. Ackett, at one time or another, was assigned to be their teacher. These videos took place between approximately January of 2017, when Mr. Ackett began his employment at Bloomingdale High School, and September 11th of 2018, when the devices were in fact discovered. There was also one adult teacher who was captured in a state of undress, changing in that same changing room, and she is the victim in the 1 3rd-degree felony count. The defendant can be identified. As I said, he is depicted on those videos. He was in the position of school employee over all of these students at the time, as per his employment at Bloomingdale High School, and all events occurred in Hillsborough County. As to 19 CF 3914, following the search warrants that were executed on the devices located in the preceding case that occurred at Bloomingdale High School, law enforcement gained access to additional devices that Mr. Ackett had possession of in December of 2018 that were still located at Bloomingdale High School. Law enforcement executed search warrants on those devices, and those search warrants revealed additional images of voyeurism. All of these images occurred at Mr. Ackett's home. They occurred at his home located in Hillsborough County. In those images, there were 3 victims depicted who were under the age of 16 at the time, and Mr. Ackett at the time, between May of 2015 and September of 2018, was over the age of 24. Those victims in those images were also depicted in a state of undress or unclothing and changing clothes in various locations in his home. Also captured on those images of voyeurisms were 2 adult victims who were again captured at his home in various states of undress and changing clothes. That is the basis for the counts in the 2019 case. The defendant can be identified, and all events in that case also occurred in Hillsborough County.
Mr. Ackett, do you understand those are the facts to which you're pleading guilty?
Yes, Your Honor.
Mr. Ackett, the court will find a sufficient factual basis, will accept your plea in both cases. I'm going to go ahead and adjudicate you at this point. We're setting off sentencing, I believe, to an agreed upon date of May. What was it, Mr. Suarez?
Your Honor, May the 10th is what your office provided us as an available date.
May 10th for sentencing in this case. I will allow you to remain out. Per my understanding, the state has agreed to allow you to remain out on pretrial release, same conditions that are currently imposed for you. Ms. Derry, is there any scheduling issues or anything else from the state at this point?
There's no scheduling issues, Judge. That is correct. We were provided the date of May the 10th at 1:30. The only inquiry I have of the court is because of the large number of victims, we are scheduled to conduct this sentencing in person. However, I expect that there are many victims who either may not be able to attend, may not be comfortable attending, or would like the option to appear on Zoom. So I'm asking if Your Honor will give us the ability that day to both conduct it in person, but also have a Zoom option available for the large number of victims. Or if that's something we can arrange.
We will do our best to accommodate that. I think, quite frankly, a hybrid approach would be better because, as you all know, the courtroom space is now very limited. So what I would ask of you and Mr. Suarez, I don't know what witnesses, if any, that you'll have, but I would ask that you all, with the state and defense, try to coordinate that ahead of time and figure out logistically with my office how to set that up so that, for example, my Zoom went down earlier today while I was in court. I lost internet and I had to log in from my cell phone, but then when I came back on, there was a bunch of cross feed and all of that. So I want to eliminate any issues and make sure that everybody can hear everything. I want the people on the screen to be able to hear what's happening in the courtroom and vice versa. I think we can accommodate that. I just want to make sure that we don't have any issues. So let's make sure that you all with our IT or your IT or however can figure that out, and we'll work with you on that.
And Judge, I believe Mr. Ackett, or I'm sorry, Mr. Suarez and myself both intend to present the court with documents in advance of sentencing. Again, I intend to present the court with all of the written victim impact statements that my office has received to date in a packet. Of course, I will provide the same to defense counsel, and I believe Mr. Suarez intended to do the same thing also, so that Your Honor has an opportunity, because of the volume of the information, to review it prior to the sentencing.
My preference would be to have that as soon as possible. My preference also would be, because of the large volume of and the number of witnesses, to try not to have anything that becomes too cumulative. So if someone's submitting a written statement, that may suffice, but I'll let you handle that however you want to, Ms. Derry. I just know that we have limited time and we have a lot of people to hear from.
I understand, Judge.
Anything, Mr. Suarez, from you in terms of scheduling or anything else?
Just very briefly, Your Honor, do you have a preference on the submission electronic, or would you rather have paper copies delivered to your office?
I much prefer paper copies, but if it's easier for you to send it electronically, I can print it.
I'll do both, Judge, just to be safe. And the only other question I have is, typically Mr. Ackett will be fingerprinted at this time. I did download the fingerprint cards, but there was not a time available prior to the hearing for him to go to the sheriff's office. They schedule appointments and they were all taken.
In this case, I don't have an issue with him getting printed at the time of sentencing, which would be that May 10th.
Great,
date.
thank you, Your Honor.
And then Ms. Derry and Mr. Suarez, if anything comes up in terms of scheduling or timing of anything, please just let me know sooner rather than later. Obviously, we have a lot of people's schedules that we're juggling here. So anything else today? Mr. Ackett, related to your open plea, and again, I haven't talked to the state, so I don't know what they're seeking yet in terms of sentencing, but you're still out on pretrial release, okay? So you can expect, if there are any violations of the law or violations of your terms of pretrial release, or for whatever reason you don't appear at your sentencing, which is your next court date of May 10th at 1:30, you can expect without question that maximum possible penalty will be the maximum sentence that I can impose. Do you understand that?
Yes, Your Honor.
Okay, and do you have any questions for me about anything?
No, Your Honor.
All right, so obviously you'll stay in good contact with Mr. Suarez, and Mr. Suarez and Ms. Derry, I'll expect to hear from you all with submissions and anything else you want me to look at, okay?
Thank you, Your Honor.
All right, I'll
Thank you,
see most all of you on May the 10th at 1:30. Thanks, everybody.
Thank you, Judge. Have a good afternoon.
Thank you, you too. Close to